Well, welcome everybody. My name is Karen Pank. I'm the Executive Director for Chief Probation Officers of California, and we are letting folks in through the waiting room. So we'll just give it a minute before we get started with the workshop today. So thank you so much for being prompt. We're just going to give some of your folks an extra minute or two to log in. And as people are rolling in, I do just want to remind folks that we are recording the workshop today. So I always like to be sure that I think you would have heard the announcement on the all right. Okay, perfect. All right, well, why don't we go ahead and get started? I know everybody is anxious to jump into it here, and I want to begin by again introducing myself, Karen Pank, the Executive Director for the Chief Probation Officers of California. Some of you are probably repeat viewers, but this is our informational workshop series where we bring forward various different things that we believe will be helpful for just either your work life, or in this situation, actually your work life kind of spilling over into your personal life or vice versa. So we're very pleased today to have one of our newest probation partners walk you through some estate planning for law enforcement professionals. Attorney Tess Detterding is going to walk us through some things, and we will be happy to help facilitate questions. She's agreed to definitely take questions either as we go or at the end. So feel free to put it in the chat or to raise your hand, and we'll go ahead and get to you as soon as it makes sense for a break in the discussion. One thing I would keep in mind is, this is a legal discussion, and so probably don't necessarily want to go too deep in the weeds on personal, very specific questions, but Tess has agreed to take your emails and questions maybe offline on some of that if you had any follow-up. But general email or general questions definitely will help all of us learn a little bit more about the subject matter as we go through it. So with that, no further ado, I'm going to turn it over to Tess. And again, thank you for making your time to be with us this afternoon.
Oh, thank you so much. The pleasure is all mine. I'm Tess Detterding. I'm an estate planning attorney located here in Fair Oaks, which is in Sacramento County. I have been practicing in estate planning for about 4 years now, and I'll get into a little bit of my background as we move along here. But the heartbeat of the firm is really estate planning for law enforcement communities because of my background and my passion for making sure that we are not just serving the communities out there on the day-to-day like you all do, but also bringing that home to our families and making sure that we're protecting the people that we even work for every day. So my goal here is to really just do a very general overview of estate planning on a basic level. And if there's something that is like more personal, more minute, more kind of into the weeds, then I'm absolutely going to provide my contact information. I'm happy to explore everybody's different situations and what we might be able to do to help you at Detterding Law. So first of all, we're going to go through, I'm sharing my screen here. Okay, here we go. I'm not the most tech savvy, so I apologize if there's a few bumps in the road. So for law enforcement, there are certainly some more specific things to consider when we talk about estate planning, just by the nature of the job and the circumstances that we all have that tend to be in common as it relates to what we go out and do every day. But as a basic overview of estate planning, there are really 5 main components that we'll get into today and talk about very specifically. Those 5 components are trusts, wills, power of attorney, advanced medical directives, and HIPAA authorizations. So here is just kind of where I'm going to go today, the areas that we'll explore, some information that I want to give about each of these particular topics. And again, if you have a question or something that, please feel free to stop me, raise a hand, or put something in the chat. I might not see it. I'm not going to be monitoring the chat, but somebody will flag me down and let me know that there's a question. So this is kind of what the agenda is going to look like. I can't imagine that we're going to want to talk about estate planning all afternoon here, especially because it is Friday. So I'm sensitive to that, and I'll make sure that not to belabor any points, but I want each of you to walk away with at least a very basic understanding of what might be needed for you, whether you're a single person, married, children, all the things that life brings, a homeowner, and all that stuff definitely lends itself to really robust conversations in the estate planning arena. Here's a little bit about me. My background is in law enforcement. I was with the Sacramento County Sheriff's Department for 15 years. I served as both a deputy and as a sergeant. With a variety of assignments, but probably most notably for a couple of years and during the COVID era and the riots downtown, I was the public information officer for the Sacramento County Sheriff's Office. So here's just a couple clippings of me doing my thing back then. That's before I transitioned into what I'm doing right now, which is really my passion. And I think that I definitely got more than enough experience to say that we can do better in law enforcement to protect ourselves and our families at home through estate planning. Unfortunately, most notably, we learned that through the tragedies that we experience in this profession with the loss of partners and experiences like that. And then in the background of that is someone who maybe could have been more prepared in the estate planning arena. So my hope is to share this message and get people on board with what they can do to help themselves in that way and their families should the unthinkable occur. On the left here are my little guys and gal. This picture was taken right before I left the Sheriff's Department. They're much older now, but certainly they're my why. And I think that we can all relate to, having people in our lives, whether it's nieces and nephews, possibly grown children, that grandchildren coming into the picture, how do we protect them? How do we have this all make sense so that there is, some predictability or smoothness to this process on the back end, should we face that, or should our partners face that one day? Okay, so we talked briefly about the 5 components of a comprehensive estate plan, and we'll go right into it. The first one being a trust. And I find that oftentimes a trust is a very buzzword when it comes to estate planning. People often say, well, I just heard that I need a trust. And while that's true, there's different types of trusts and different reasons for our implementation of them. Most notably being what's called a revocable living trust, which is what many of you and myself and my colleagues would be after when we're talking about establishing a trust. I often tell my clients to think of a trust as a bucket. So we're building a bucket. But more importantly than building the bucket, which is an important part, is actually putting things inside of the bucket. So if you think of it as like, so the courts, somebody passes and the courts say, okay, great, you had a revocable living trust while you were alive and you passed, and now we have these distribution terms that you've laid out in your trust. Let's say, it's going 50-50 to 2 children. Well, if I haven't put my house in the trust, notably my bank accounts and some of the bigger assets that I have in my life, then it really doesn't mean anything because I'm holding an empty bucket. So in part of the process that we talk about in our estate planning journey is this idea that we build the trust, but then we also walk the journey of making sure that a house is titled in the trust and things like that so that it has actual meaning. And with a revocable living trust, the revocable part being that I can take things in and out of it throughout my lifetime. So I'm not committed to anything in terms of, well, if I own the house now, but at some time down the line, I'm going to sell the house, I'm going to buy a new house, buy a new house. Your trust moves with you through all of those processes. So nothing to be concerned about in terms of this is in stone, it's unshakable. No, it's certainly not the case. Again, if we go back to the bucket reference, just as easily as we can put things in, we can take things out and put other things inside of it. So one of the main things about that trust, like I had just mentioned, was this idea of disbursement or distribution upon one's death. So often in our cases, it's pretty linear. So it'll go from, a parent or parents to children and then on to grandchildren and so forth. Obviously, some circumstances are a little bit more complex. There may have been a prior marriage with a child from that marriage, and then another child or stepchildren from a subsequent marriage. So there's certainly things to consider within our analysis of the living trust, but this is where all of that conversation would occur inside of this revocable living trust, that certainly the terms are changed over someone's lifetime as their circumstances change. For example, a very common one is when we do a living trust initially with a couple or an individual, their child or children might be minors. So the considerations that they have during that time are much different than a distribution that might take place to an adult child. Once they reach the age of 18, 20, 25, we look at kind of different schemes in terms of what that distribution might be. But it's very important that while the children are minors, that we put things in place such as creating their own trust if you were to pass while they're still a minor, so that they can be cared for, right? Their education, their other expenses, just living expenses, while they're still under the age of 18. One very important piece to a living trust is that it avoids probate. It's actually the only thing in California that does avoid probate. People, probate again is kind of another buzzword like a trust, but probate is that nasty process that usually people only become familiar with because they have a friend or a family member that had to go through that unfortunate process of probate. Here in California, because of the state of the courts, it's usually an extremely lengthy process. And for me, I think one of the worst parts of probate is that a portion of that estate does go to California, or go to the attorneys that are running that probate. And so one of the really nice things about a trust is that it does keep that estate, that hard-earned money, all of those assets to the beneficiaries, to the people you want it to go to, not to contribute more to, some things that you might not want to be contributing to. So a trust really is kind of the introductory, most important piece, arguably, of that estate plan or starting that estate plan process. Is there anything with trust before we move on to wills? I saw that maybe there's something in the chat.
I was just reminding folks to put their questions in the chat if they wanted to along the way. So far, no questions yet. Good. Oh, wait, or is that just, yep. All right, I'll interrupt you if it comes up.
Perfect. So hopefully I'm making a lot of sense so far then.
That's how I would read it.
Good. So the second of the 5 components that we'll cover is the will. And oftentimes people, their familiarity with a will is that people will scratch something down on paper or just have something very basic laid out. And for some people that can work. And most notably, it will be older clients that don't have maybe some larger assets. So not a homeowner, somebody with very basic, maybe they have some Social Security coming in, things of that nature, but nothing that would reach maybe like $150,000 mark and over. And the reason for that is that there is an expedited process through the California courts that avoids kind of that nasty probate, and can expedite that will process. Because if you just have a will and you are over that about roughly 150,000, then you do go through the full probate process, even though you have a will. And I think sometimes that can be lost on people. Well, I have it in writing, right? Well, it's not in the way that we want to have it in writing. To have the full coverage and to avoid that probate process, you do need to have a trust. But when you have a trust, and certainly through our process here, there's something called a pour over will. So you do have a will alongside your trust. And the purpose of that pour over will, if you think of it as like a jar of water and you've got your bucket, your trust, then the pour over will just pours anything over into the trust that might have been lost through your lifetime. Hey, I intended to have that account, or maybe that safety deposit box. I intended to have that named in my trust as an asset of mine. But for whatever reason, it didn't get put in there. That pour over will is saying, hey, whatever assets I accumulate during my lifetime, it is my intention that those be thought of as being included in the trust. So that's one big purpose of having that pour over will in place. The pour over will also includes guardianship for minor children, which is, I think, very important to anybody who is raising young children. Is where would they go in the event that I'm not around to be caring for them when they're minors? And that's where we would be able to introduce that language, is in that pour over will, or a standalone document we often use is just a guardianship nomination. So we would be exploring those types of questions in the area of the will.
Tess, we had, I think you just answered one of the first questions, but is it only a revocable trust that allows you to avoid probate? I think that was yes. Okay, good. And then I'm sure it was something that's on everybody's mind is do you have further information or a link that would take folks to what the cost of doing something like this might look like?
Oh, absolutely. And so in the end, I'll provide all my information. We, like I said, we're aimed at law enforcement. So a big part of what we do here is keep costs really low for our law enforcement folks. And so on the website, it's very transparent about what that might look like, whether you're an individual person or a married couple. The cost is just slightly different. It's about twice the stack of papers for a married family as it is to an individual. But we walk that process together parallel with the two spouses. And so there's some joint decisions and then some individual decisions that go into that. But in terms of cost, that is on the website, which is publicsafetyplanning.com. And that'll be towards the end of the slide if people want to explore that more as well.
Perfect. Thank you.
Yeah, absolutely. So component 3 out of 5, which we're about halfway through the main components of your comprehensive estate plan, or what you would want to have included if you are going to hopefully have an estate plan in place, and that's the power of attorney. So when we talk about power of attorney in terms of an estate plan, we are talking about financial. So this is the power for someone to step in your shoes and make financial decisions regarding your assets during a time of incapacitation. Now, this is different than, somebody that you would name as a successor trustee, or someone that would take over the decisions of your trust, because if your trust is enacted, then you've passed, right? So this doesn't require death. This is during, let's say that you suffer an unforeseen injury in the field while you're working, or even, just living life. There's maybe a car accident or something that leaves you in a state of not being able to take care of financial affairs for some period of time. Your designated agent under your power of attorney will have the power to go in, assume bank accounts and make, the bills that need to be paid during that time, make those financial decisions on your behalf as if they were you. So they would step into your shoes to be able to make those financial decisions. And this one, I can't really stress enough the next two. So power of attorney, and then the advanced healthcare directive, which is the healthcare side of a power of attorney. It's extremely difficult. I've had clients that have, come to me on the back end as opposed to the front end. And, banks and institutions like that, you try and walk in there and say, hey, listen, my mom or my son or my whoever is in this position and they're unable to make these decisions right now. They will make you jump through all kinds of hoops and to extend that access, or that make that process very lengthy. But having this in place already, having it notarized and having it in hand really just quells some of that right off the bat, and lets you just get down to business and focus on what needs to be done, as opposed to try and gain the access on the back end. It can be very difficult. Advanced healthcare directive. So this is component 4 of the 5. This is just like we were talking about the power of attorney being financial. This is essentially the same thing, but for your healthcare decisions. So again, you're in a position where you're incapacitated, you're unable to make these healthcare decisions for yourself. I often have clients come in and say, well, I'm assuming when my spouse comes in that they're just going to give them the rundown and let them know what's going on and have them be involved. And that's not always the case, especially in California. We have some very strict HIPAA laws and things like that to overcome in order to invite people into those conversations and let them know what your health condition is and what might be able to be done. So this makes all those decisions on the front end again. So we're getting out in front of anything. The other thing is that I tell people, because of course my job is to be doomsday, what if that car accident is with you and the spouse? So there isn't someone that automatically you would think would carry kind of that weight as they come in to make those decisions. Who would be then the backup agent to the spouse? That's something that we explore in all of these documents. And what type of, maybe parameters would you want to put on that person? In other words, do I have some strong beliefs about what kind of care that I would want to receive? If I'm on life support, is there some parameter to that? Is there something that I would want someone to know if they were left making those decisions on my behalf? And so all of that, again, is articulated in these documents, and very important, I think, to explore that before the time comes, so that there's not those hurdles to jump through with hospitals and administration and things like that on the back end. And again, like I say here, access is key. So especially if this is a timely decision, right? I mean, if there's decisions related to healthcare that need to happen now, then we want people to have that access immediately and start gaining that information without, bumps in the road of, is this person eligible to be involved or not? Component 5 of the 5 is that HIPAA authorization. I just talked about the strict guidelines that hospitals and administrators are under in terms of releasing your confidential medical information. This is an expressway to that access. So the same people that we would have listed on your advanced medical directives as your agent are then going to be listed on your HIPAA authorization, and that gives them that access, that piece of paper that's notarized to say, hey, listen, I'm a person that's been put in charge of this as an agent. You can also have agents acting jointly. So let's say that there's 2 people that you would want to make that decision on your behalf as kind of a joint decision, maybe, hashing something out together. Then that's something that certainly can be considered when you draft these documents as well. Okay. So this is where I like to kind of get into a little bit more of like a law enforcement focused, certainly working as in-house counsel for the sheriff's department for many years. Asset protection is a huge piece to when we talk about trusts and estate planning, because we are all, we live in a very lawsuit happy, certainly state, but profession. Absolutely. So when we talk about lawsuits and, especially when we go to civil court, there's a federal lawsuit, often, of course, and hopefully our agencies are protecting us. They're offering that buffer, the liability doesn't fall on us personally. But certainly if that were to happen, then we want to have our assets protected to a certain extent, or to whatever extent that we can, right? Nothing is perfect. I'm not saying that if you put all your stuff into a trust that there's no way to be able to breach that and be able to access assets, but it certainly creates another level of protection. So instead of me, Tess Detterding, owning a house, right? My Revocable Living Trust is the entity that owns the house, and I'm the grantor of the trust. So there's a layer between me and that house, right? And my trust dictates what that would look like in terms of my passing and what that distribution will be. And that also can be set to protect against predators and creditors and things like that. So if something were to come to light after I've passed, then that entity or agency would have to jump through hoops to say, hey, we're going to overcome, this legal jargon here that says that we can't have access to the assets in this trust, as opposed to just coming after someone personally and having that personal exposure. So certainly something to think about in the law enforcement realm, and our exposure to, a lot of people that want to say we've done something wrong in the way that we are doing our jobs. Guardianship and special needs. We touched on this a little bit when we talked about, saying who it would be raising our children, either physically or financially, as they're minors, and if we're not here to do that. Another thing that I come across a lot is kind of this special needs conversation. Is there a child that maybe is on the autism spectrum, or has some other special need that we're not sure, if this child is going to be in a place at 18 or 20 or 25 to be able to care for themselves in that way, especially if the child's really young right now. So there's really important things that we can put in place that create some buffers for that child specifically as they grow. And then again, because we have control over all this stuff, then we can lift those if, as time goes on and circumstances change, we can revisit those conversations, and maybe those, mechanisms don't need to be in place anymore. Another thing to mention here in terms of special needs is that, if I'm gone, I can't predict, what's going to happen to one or any of my minor children. So let's say that there's an accident after I've passed and a child requires maybe some government assistance to care for them, in a wheelchair or whatever, the circumstances might be, then we've already put things in place. We have language there that allows that child to qualify for a government assistance without looking at maybe how they benefit from the trust assets, if that makes sense. So that they can still get the help that they need without showing, oh, this child is a beneficiary of a $500,000 trust, a $2 million trust. They don't need, to have those state benefits or whatever have you. There's things that we can put in place to allow that child to still have access to those services without needing to claim those assets as an actual asset that they hold. So those things can become really important as time goes on. And I always tell my clients too, it's like we have to plan for everything, because we cannot possibly, plan for very specific things or even predict what they might be. So there's a lot of things that we put in place just as placeholders or buffers or just in cases for all kinds of circumstances. Estate tax preparation is also a part of your estate planning process. It kind of goes hand in hand as you weave through maybe the terms of what you want to put in place. I can tell you right now, the federal state tax threshold is extremely high, around $12.5 million. But there's a lot of talk in this field about that number going down quite a bit over probably the next, generation or so. And if that were to occur, then there's a lot of people that, without even maybe realizing it, might be buffering right up against that federal estate tax. So what that might look like is, I've worked my whole life to build my assets. I pass at age 75, and I didn't do any estate planning provisions. Now my total estate is worth more than that threshold. And you better believe it, the federal government's going to go in and grab a chunk of that estate and take it as an estate tax. So there's things that we also put in place during this process that allow for different buckets. We talked about that trust being a bucket. We can actually put things in place that allows for different buckets to be created. And when that happens, then you can split the assets between those buckets and lower the amount that's in each of those buckets. So if 3 million is spread across 3 buckets, 1 million, 1 million, 1 million, because we've created these little caveats, then, and the federal threshold is 2 million, then you're covered, because they can only look at one bucket at a time separately. So that's another very important piece that we incorporate into the estate planning process. California does not at this time have an estate tax. So that's, if that were to come to pass, then we would need to go in, and whatever that would be, then we would create the same type of placeholders in order to cover our clients with regards to a California estate tax. But again, that's not in place as of now. Choosing successor trustees and agents is a big part of the conversation that we go through when we look at creating trusts and all the other documents that we discussed. How to identify a person in your life that you would want to name as that successor trustee. And what I mean by that is, when you create the trust, let's say it's a married couple. So the spouse, the surviving spouse, as we call them, because you will have, in order for the trust to be enacted or administered, someone has to pass away, right? So we have the decedent or the deceased spouse, and then we have the surviving spouse. So most commonly, the surviving spouse is the sole trustee of that trust during their lifetime. And then when they pass, then it goes down to another agent. So Typically, it's maybe an adult child that you've identified as somebody that could take on that administration. What that looks like is a lot of paperwork and a lot of making sure that the way that you wanted things to be distributed is being done in line with your wishes. And then in terms of agents, it's the same thing, but it's with that power of attorney and the advanced medical directives, the HIPAA authorizations. Who would I want or trust in my life to be able to take on those roles? And it doesn't always have to be somebody that I can identify in my life, a friend, a family member. There's professionals that handle those duties as well. I may feel more comfortable when my kids are minors. And if it's not my spouse, that I would want a professional trustee to step in and be able to distribute those assets, especially if there's some concerns about, disinherited people within my family, or, things might be a little bit more contentious. I can see that coming. And so I would want to remove that from someone in the family just to alleviate stressors or maybe some infighting that successor trustee would have to handle. So again, that's a little bit more formatted to, people's individual circumstances, but definitely something that we consider in this process as well. So quite a bit of time spent, if needed, exploring kind of who those people might be and for what reasons. Oftentimes the conversation around the financial power of attorney is different than the conversation around the advanced medical agent, because medical decisions are much more emotional, right? It's maybe somebody that I really want to know me and to know, who I am in my heart and what I would want someone to make in terms of decisions for health. And then I may choose a family member or a friend or someone who's really financially savvy and that I trust, with money to handle maybe the financial agent. So again, really robust conversations can go on when we talk about identifying, but we definitely, make sure that people feel comfortable with who they identify as these people in the documents. With that being said, nothing is in stone, as I said before about the trust. So people will say, well, what if I want to change that person? You're going to have, right, your entirety of your estate plan in a binder, pages and pages of legal stuff and signatures and things. But when we talk about just, let's say, trading out a trustee, it's a single document, right? So, in place of, Joe Smith, I'm going to put, Ben Jones. And that's a single line, single piece of paper that you can then add to your portfolio, your estate planning portfolio. And that effectively changes out that trustee, or in the case of an agent for financial or medical, it would then transfer out that agent and put the new one in place. So very simple to make amendments throughout your lifetime. Once you do this once, it's really kind of the overhaul. Something that I also tell people a lot is, like, when you first form the trust or the comprehensive estate plan, it's like the framing of a house, the foundation and the framework. But throughout time, you can knock down walls, add a bathroom, do all that stuff, but you've already done, the critical kind of infrastructure part of your estate planning. So that's nice because you really only have to jump that hurdle one time, until you get to a point of about 10 years down the road or so. Then we kind of encourage people to do a complete overhaul, because laws change and certainly family circumstances typically change, especially for, people that have younger families as they grow up. And again, kids become adults and things like that. Then you may want to put them as agents where, you wouldn't have before. So we stay with you through a lifetime. I mean, any attorney that you go to for these types of documents should be able to do those simple amendments and things like that. And with that said, if you started somewhere and you need to do an amendment, you don't have to go back to the original entity that you were at. You can go and get that done somewhere else. And especially if you move, or if you, things like that.
So a couple of questions at this stage. So as you were, that was helpful to know, hey, you have to maybe put aside some time to build that framework, and then you're kind of just checking in on it and then maybe revisiting it, every 10 years or so. But what, and I know this may be difficult to answer because it may depend on all of the specific circumstances of your situation, but in general terms, how much time should people kind of set aside to really do that first build out of the framework?
Great question. I think that it's different only in terms of what people have access to currently in terms of their financial asset information. And what I mean by that is, so in our process, let's say again, it's a married couple, it's about a 15-page intake worksheet that you work through with your spouse. Some of that's very easy information. It's identifying information, addresses and phone numbers of people that you want to be successor trustees or agents, kids information, things like that. Other things are a little bit more nitty gritty and might take some time depending on if you need to talk it out. And certainly the sections that talk about, bank account information with the last four of accounts, life insurance policies, retirement accounts, 401k or 457 accounts, stocks and bonds, things like that might take a little bit more time to reach out to those entities and kind of gather that information. So it depends on how, I guess, I don't want to say organized because I'm certainly not the pinnacle of that, but if people already have that information readily available, it can be much more streamlined. But we, and I would say, any law firm that you work with, really kind of works on your timeline. So if it's a super busy season and you want to get it started, but that intake worksheet might take a little bit longer, we're just basically like, hey, let us know, what works with your timeline. I'm not going to put it's not homework, right? So I'm not going to put any pressure on you to get that back right away. But certainly it starts that clock for us once we have all the information. We can start, drafting the documents and having a little bit more in-depth conversations about, your circumstance and what you would be looking for in terms of the terms of your trust and those other documents. But I would say, I can't imagine that it would take, it just working on it spotty here and there more than a couple weeks to kind of gather everything you need. And some people supercharge that and they want to sit down in one night and knock it out. But yeah, I would say you're looking at about 15 pages of, some stuff that's real easy and some that's more streamlined.
And then a really good question in the chat. Is there a recommended age to begin the process?
Now, the age you are now.
Good answer. And probably one that, people don't really think of. I know I'm guilty of always procrastinating, and this is not always the easiest subject to want to tackle. So, so very good advice. Another question in the chat, can the estate tax planning take care of taxes upon distribution?
Yes. And so I can't offer tax advice, of course, because I did not go to
Right.
that. I'm not smart enough for that. But with good advice from like a CPA or somebody to work alongside with in that regard, a lot of that stuff can be ironed out before distribution. There's a final tax filing that occurs after somebody passes. And so, a good tax prep person, CPA, would be able to, really get down to like what would need to be claimed and not, and how that would iron out. But we try to make that as, as low as we possibly can in terms of our languaging. But of course, there's tax experts that could probably do a whole webinar like this and actually give some really good advice about that. So that's a little bit harder on my end to be able to talk about. But we do try to have an eye on what that might look like. And again, some of that goes down to those different buckets that we talked about. So separating some of the assets out so that it's not one big hit.
That makes sense. And then while we're kind of going over the chat here, just a couple of others, can a spouse be in a different trust?
Yes. Yes, we have had that. It becomes a little bit complicated with community property, but what we have had is, maybe some really good prenuptial agreements that really delineate, whose assets would be attributable to who, so that you're working more with separate assets than you are community property. So the caveat to that, yes, we can, but it's hard when you're talking about community property assets. So it kind of starts to blend into family law there. So I'd have to see what that person has or what would be the reasoning behind that. Most often I would say it's later marriages, maybe second marriages later in life. And so an individual wants their assets to go to their lineage, as opposed to crossing over into the later spouses who already has grown children type of lineage. So those conversations certainly can be had. The short answer to that is yes, but it can become complicated with community property.
Yeah, and I would imagine a lot of these types of questions will start to get complicated by community property and just the other set of laws attached to that. But there's another question is how hard is it to make a trust when two people are not actually married, but have shared assets such as home, savings, kids, etc. Is that the same answer? You know, these things can be addressed, but they just become more complex.
Yeah, so depending on the assets and how intertwined they are, we could go one of two ways. It could be two separate trusts, or it could be a combined trust. It doesn't have to be necessarily. The most common one for married is the joint because of the community property aspect, but you could have two people whose assets are so intertwined that that makes more sense. It will just totally depend on the individual circumstance.
Great.
One other thing I wanted to mention while we were talking here is, if you do venture into this estate planning process, wherever you go, one very important piece is that the largest asset you have, which for most people is going to be a home, that the documents are prepared to put that house into the trust, like right off the top. Because what I've found is that people aren't going to go out and do that on their own, and it requires a quitclaim deed and then a PCOR, a preliminary change of ownership report from that county recorder's office, and then for those documents to be recorded. So if you are going to venture into this, make sure that that's a part of the process that's offered. We do it as just part of the process, just point blank, because I'm not going to let anybody go out there and just say, oh, well, I'm going to take care of that, because I just don't think that that's going to happen. Not because people don't intend to, but like we all know, life gets busy and it's like, oops, right. And it can be a little bit complicated. So I find it's better just to do that as part of the process. So, if you're taking notes or whatever, just write down, make sure the deed is taken care of, and that that deed of trust is changed be titled into the trust.
Super helpful. And this may be a good place as we're kind of getting into the next piece of your presentation, just to remind folks that I put it in the chat, but we will have materials at the end. You'll have a contact for Tess. A lot of this information, I mean, people will not, I would imagine, be able to leave this excellent workshop and have all of their questions likely answered for their specific situation, but it is meant to arm you with the right types of questions, the types of things you may need to be thinking about, no matter who or when you start to address these issues. So we will distribute any materials as well as the recording today for those of you who are on this workshop, just because again, I know it's dense material, it's hard to get through, and I know myself, I might want to re-listen to this again a time or two.
Yeah, and it's I'm doing like a very skim overview of everything, and so I know that it's probably just pops up a ton of questions in people's minds, which is really good. I mean it when I say reach out to me. You guys will have I'll have my contact information, even if it's just a conversation. Like, hey, Tess, like, what do you think about this? I'm happy to have those conversations. It doesn't mean that you even need to do anything right now. It might just be like, hey, I'm getting married in a year. Do I do it now? Do I wait till I get married? All of those things, like for people's specific circumstances, I'm happy to just jump on a phone call and talk through whatever needs to be talked through. So keep that in mind as we walk through this. I definitely don't think that you're going to walk away thinking like, oh, I know exactly what I need to do and what this looks like. But hopefully you kind of have I guess a little quick guidebook of, what is estate planning and what are the components that I want to look out for if I'm going to, do this. The other thing about the house and the assets going in, because I've had a lot of people say, well, what if I go to LegalZoom and I create, a trust and things like that? I'm not opposed to anything. My message is like, have something in place. There's certainly, you get what you pay for kind of conversations when it comes to this stuff. But with that being said, if that's something that you're inclined to do, maybe do like if you're going to do a templated, let's say, something that you find, or go through a LegalZoom, the most important component to that is understanding that the funding is left to you. In other words, filling that bucket with the assets is arguably more important than going on LegalZoom and printing out the trust, because the trust doesn't have any meaning unless there's something in it. So that's something that I want to make sure that people really understand. So if you do venture out and you're kind of trying to piecemeal it yourself, just make sure that things are actually being titled into the trust or put into the trust. And that might even just be going into your bank, let's say Golden One, and say, hey, Golden One, I created a trust. Here's the name of the trust. Here's my certificate of trust, which we didn't even get into today, but that's your single piece of paper that shows that a trust exists and that you are the grantor, so you are in charge of it. And then they can keep that on file so that if something were to happen, then they have, direction as to who the successor trustee is, and that this trust is in place, and that the trust is tied to your bank account. And there's also something that we do through the trust process. It's called the Schedule A. The Schedule A is a list of your assets. And that's some of that undertaking that we do when we build that foundation is, any cars or, boats, motorhomes, bank accounts, anything like that. The education savings for your kids, accounts that, might just be lingering out there, gathering them all into one place and showing, it's my intention that all these accounts are in my bucket, my trust bucket. So just that caveat, start thinking about, yes, it's good to create one, more important to put things inside of it.
Really important distinction. I always love to point out aha moments that I come across my head as I'm listening to certain things. And so hopefully folks, I want to just underscore that, because I think for those who might be not as well versed in some of this area, you may think, of the more traditional will, I'm just saying what I want to have done with something versus actually physically and legally, filling up the bucket, as you were saying. That's a really great point.
Yes, exactly. And I think, yeah, there's that sense of, oh, well, I have a trust. Well, let's look at what does that mean, and what is actually inside of that trust. So yes, that's something that I feel like I repeat myself over and over again. But I do think, and I'm glad that you said it was like an aha moment, because I think sometimes that there is kind of that, you have to bridge that gap between I do have a piece of paper, but there's nothing that I did in relation to that piece of paper. And that actually gracefully goes into our next point. So failure to update regularly. This is coming from my law enforcement heart now. When we're all for me, it's first day at the academy, right? Little 23-year-old me is oh, my beneficiaries, right? Sure, my mom can have everything and whatever. I'm unmarried, I don't have any. But then what happens is throughout our careers, we never go back and take a look at what that says. And so oftentimes, well, I don't want to say oftentimes, I have known of more than one time that, something happens and they go back and the ex-spouse is named as the beneficiary on things, or it's haphazard and somebody over here, it's a decision that we made 2 decades ago. So I always encourage people in all of our calls to go back and look at all the things that you have people named on, whether it's life insurance policies or something through your department, or just all of the things that we might be gifting to someone in our passing, and make sure that it's set up the way that you want it to. And then if you are in the process of creating a trust or you're setting up an estate plan, then those entities need to know that you have a trust as well. And what they'll do at your direction is to put the trust as a backup beneficiary. And where that might come into play is, let's say, for me, my spouse is my beneficiary on my life insurance plan. Well, if we die in a car accident together, then they have no beneficiary to give those benefits to. But if the trust is the backup beneficiary to my life insurance policy, then it can filter through that trust and then go to my next in line beneficiary. So we're actually covering, if there's, and what we say in the field is, if there's no one there to take, right? There's no one there to take that asset, then how do we make sure that the next in line can step up to be able to receive those benefits? So that becomes really important when we do have longstanding careers at one place and our lives have changed throughout the years, but we haven't gone back to make sure that those things are correct. So super important to know who's on there. The other thing is, like life insurance is a great example because life insurance companies don't care that you have a trust and that you named someone in your trust to get your life insurance. They don't care. They're going to go off of who it is that you wrote down on their intake paperwork when submitted to get their life insurance. They're going to disperse to the person that you have listed. So that's a fight that we'll lose every time to try and say, no, but in the trust documents, they said they want, little Jimmy to get life insurance policy. Like, we don't care because they wrote down Sally on their beneficiary when they signed up. And so Sally already has the money. You can bet that they already mailed it out because they're trying to get that stuff right turned around and out. So another really good reason to go back and make sure that that's in place and that they know that you have a trust and that you want that to be the backup. So failure to update regularly, it's like, let's just stay in contact with whomever that you go through your estate planning process with to make sure, hey, have any changes in the law occurred over the last 2 or 3 years? Is there anything I should be aware of that I should update within my trust? Certainly as life events occur, then revisiting that trust if there's something that needs to change, making sure that if the entity that you went through to create the estate plan isn't keeping tabs with you, that you're keeping tabs with them, or you're keeping yourself updated so that your documents are reflective of what you actually want now. And that is all I have. I'm happy to stay on and continue to ask or answer questions, not ask questions, to continue to answer questions. But here's all my contact information. The phone number on there is my cell phone number, so you can call and leave a message if I don't answer, or send me a text and say, hey, I'm Joe, I'd like to talk. And we can work on a time. And then certainly my email address. The publicsafetyplanning.com is the hub for signing up as a law enforcement officer. That includes sworn or non-sworn or whatever position in law enforcement that you are. It's all inclusive. So position doesn't matter in this case. And then go on there and just, I'm interested in as an individual or a married couple, or I just have some questions to ask you about what I might be looking for. And certainly all of the information about pricing and stuff is on there as a way to, as well as a way to reach out to our office and set up a meeting.
That's great. Tess, one of the questions that I wanted to start with that we haven't gotten to yet in the chat, which probably is very general and is on everyone else's mind as well. If they already have a trust, is it possible to still, kind of go through the process you just outlined and maybe have your company review it and make sure we have everything that's needed to be included?
Great question. Absolutely. And I covered it briefly a while ago, so and I don't know if everybody caught it, but about every 10 years, you're going to want to look at a total revamp. And what that's called is a restatement. So it's a restatement of a trust. And what happens is you get an entirely new portfolio, estate planning portfolio. All of your documents are restated. So it maintains that title, the same name that it originally had. The reason for that is if we have assets in it already, we don't want to go messing up, right, the assets that have already been put into your bucket. So we just we put some patchwork on the bucket and we make it all shiny and new again. But it maintains the same name and things like that. So, but if you're within that 0 to 10 years, absolutely. I mean, reach out to us. I'm happy to look over what anybody has, maybe give some pointers. It might be something that it's just a simple amendment that you need. Like, hey, we just want to switch out some names. What might that look like? And we're happy to work with you on just a few things or a total overhaul if that's what's needed. But we'll give you definitely honest feedback in that regard.
That's really appreciated. And I'm sure there's quite a few people in that particular boat, sticking with our, water analogies, buckets and boats and all, but and homes in perhaps other states. So really good question. I know this is maybe a little bit getting into some of the specifics, but I'm going to guess that there might be a few people who are in this boat. You have a home in California, maybe you rent it out, but you move out of state. Do you need a new trust in the new state that you move to?
The short answer is no. There's a lot of things we deal with this quite a bit. And it's very much specific to the circumstances, but I will say a few things as just a general analysis that we'll go through. So a very common thing we have is, let's say, homeowner in California, and then they have like an investment property in Tennessee, or maybe they are, the plan is to move there in the next 5, 10 years. So what we'll do here is link up with a Tennessee attorney throughout the estate planning process. And then that attorney will make sure that the paperwork is done to put that Tennessee house into the trust, into the California trust. But it is a different process in each state. So we do link up with other legal professionals to make sure that it's done correctly on their end, so that Tennessee recognizes it as being a part of this California trust. But it is important that those out-of-state assets do come into the trust. Now, there's different arguments about, do I need a California trust versus a Tennessee trust? But I would say that that has to do with like a little bit more of an in-depth conversation about where were you married, because we have community property right here in California. If you have a long-term marriage in California and you're kind of 1 foot in and 1 foot out, more than likely it's going to be recommended that you have a trust here in California, and then we make sure that those assets are covered in the California trust. If there's a total move, then it's not immediate, but at some point, if you're a longstanding resident of another state, then it may be prudent to take a look at whether or not we need to wrap up the trust here and then, have it be exclusively in that state, since that's the process it'll be going through. But I would say 9 times out of 10, it's the opposite. We handle it here. You have a California marriage. Most of your time has been spent in this state, and then you have some assets we need to account for outside of the state.
And sticking with property, does the trust, placing the property in a trust, result in a reassessment of property taxes? Now, this is, I know, a tax question, and there are quite a few tax questions, but curious if, because I would imagine that's on a lot of people's mind, at least with California property.
Great question. No, it does not trigger a reassessment. There's an exemption that's used. So
Right.
one of the exemptions is moving an asset from personal ownership into a revocable living trust for the benefit of the grantor and or the grantor's spouse. So that is the exemption that we use 99% of the time, and it does not trigger a reassessment.
Okay. And then, is a living trust a tax write-off? Again, feel free to say that's more of a tax question, but that probably is one that also comes up often.
Yeah, more of a tax question. I guess it's how creative or comfortable is your tax preparer with
Right.
that type of write-off?
Fair enough. And but do you know if there is a dollar amount, at what dollar amount does probate tax? Do we know that?
At what dollar amount does probate tax? So probate is an interesting beast. Um, the threshold, and I don't have the exact number. It's between 120 and 150. It's moving constantly. So 120 and 150 in total assets will put you into that lengthy probate process, but it works on percentages. So the first like 100,000, excuse me, the first like 100,000 is 4%, and then the next 100,000 is like 2%. Don't quote me on this because I don't do probate, but it works in percentages throughout the process. So the higher that the probate estate is, then it will be taxed in brackets as you go up to, like, let's say $1 million, and that last portion of the estate would be taxed at like 1% or something like that. So it's a sliding scale, but the higher it is, the less that they're taking of that higher amount. But certainly the lower amounts, they're taking a big grab in the initial hundreds of thousands.
Great. We had a couple of questions on debt and how that's kind of factored in here. So one, for example, was if there is a trust and credit card debt is only in the deceased name, is the estate or the trust responsible for the debt? And then another one is credit card or any other debt passed on to the estate, even if it's not in the trust?
So there's certain parts of there's certain debt that can be carried into death. Like if there's debt to related to medical bills and things like that, that maybe the state might want to come and inquire about what might be left in terms of an estate after the person passes. But the creation of the trust in and of itself doesn't doesn't either create more of a burden in terms of debt or less of a burden in terms of debt, as required by law, if that makes sense. So it's not going to be helpful in terms of shielding in some ways. In some ways it can, but it's not going to produce more of an obligation to repay a debt than otherwise would be available by law to the person who owns the debt, if that makes sense. So if they would be able to come and inquire about it, just if the person hadn't created a trust or anything, then that would still be available. But the trust is mainly going to be distributing the positive assets that are with that person and their estate when they pass, as opposed to concentrating more on what debts might exist. That would have to be navigated as those debts arose and then as it related to the terms of the trust at the time of death. So it's kind of hard to answer that question, but I would say the trust focuses more on the positive assets as opposed to what debt might have been created during the lifetime.
Right,
But
that's identifiable when you put
yes,
your debt is going to be more it'll morph over time, I would imagine. So
exactly. And it depends on what the terms of that debt was, right? So if and I don't know if I'm explaining that very well, but it's not going to create any more of an obligation to repay something simply by the existence of the trust.
yeah.
Um, if anything, it would probably create more protection in some cases than exposure because it does have that layer. I'm trying to think if I have a good example that I can use. The other thing is that the trust language will account for or allow for the trustee to pay certain debts upon the passing. I mean, obviously there's expenses that are incurred just by way of the person passing. And so that language is built in, but never specific enough to tie somebody's hands to, oh, my outstanding credit card debt is going to be paid by my estate at the time of my passing. That would have to be negotiated based on the terms of the debt again at the time of the person's passing and whether or not that those funds would be available to the creditor, but will not create any more obligation than the person would have had they passed without a trust.
That's helpful. No, I think that's probably the most general and most important piece of the advice, on that level, because then, anything that flows from there is probably a little bit more specific and probably a good example of one of those questions that may make more sense for you to talk through offline. And then as people are trying to be prepared, I mean, as law enforcement folks and probation in general, it definitely likes to be prepared. It looks like the question was, is there a place for us to maybe look and download the intake worksheet? You mentioned a 15-page worksheet, so that folks can kind of be thinking about the types of things that they might need to get ready.
Sure, absolutely. As a matter of fact, I can share it with you when we get off the call. And if you want to just send that to people, yeah, absolutely. I mean, the more that people spend time thinking about what assets are out there or what questions I may need to answer when I start forging this journey, I'm happy to share the intake worksheet and have people just kind of cruise through it and see.
Right, great. Saves time probably on the back end too, so
Absolutely.
that would be good. Well,
Perfect.
good.
Thank you.
I think we got to most of the questions, at least the ones that were a little more general in nature. Again, can't thank you enough for being willing to take questions. I just want to ask if there was anybody who didn't want me to read off the question or didn't want to take the time to write it in the chat, but maybe want to explain it and wants to come off mute and ask the question themselves before we jump off. One question in the chat: do you service Southern California as well as
Yes,
Northern?
absolutely. We're licensed throughout the state of California. So anywhere within those parameters, we're good to go. And we actually often serve a lot of people in other counties. And we have a process of, putting the binder together, having all of the notarized signatures labeled for notary, as well as the witnessed. We didn't even get into that, but some of these documents require a notary and some of them require a couple of witnesses to their signing. So putting a comprehensive kind of little, deal together and then get it mailed out, certified mail, so that we can track it. And then when it lands with you, then ensuring that you can find your way to either a mobile notary or, oftentimes maybe banking institutions will do a complimentary signing for their clients and things like that. So helping you navigate how to get to that space as well. If you're here and local, then we have a mobile notary that we work with that can go sit at your kitchen table with you and go through the documents. And all of them are very familiar with our documents and can get through that process fairly quickly. But out of the area, we'll certainly facilitate that as well to the best we can and make sure that, you're seeing the process all the way through.
So you take virtual appointments essentially in that case.
Honestly, like through the 2020 and on,
Yeah.
I'd say a majority of our stuff is over Zoom. So very, very familiar and comfortable with that setting, as long as that's okay, for the client. We also have a brick and mortar here in Fair Oaks. So if that's more comfortable for folks, then we offer that as well.
Great. All right. I can't tell you how informative, as many people are saying in the chat, this
Good.
presentation was. So thank you so much. And again, just to reiterate, we will send all of this information. Katie will get it packaged up so that you have all of it in one email. Since you stayed for the workshop, that's the going home prize. And we'll have the recording as well, because you're okay with that, right? Tess, we can send out the recording too, because I'm sure people want to, again, listen to it maybe more than once.
Absolutely. Anything that's helpful to your folks, I'm all in.
Great. Well, thank you so much. And thank all of you who joined today, and look forward to getting the information out to everybody. And I look forward to working with you more in the future. Tess, appreciate your time today on a Friday. Everybody have a great weekend.